Hi, good morning, everyone. Thank you very much for joining us. I'm David Goodbrand, and I'm a partner in the technology and commercial team at Burness Paull, and I'm really delighted to welcome you to the first of 3 sessions that we will run over the course of the summer on data privacy and data privacy issues. So I'm joined today by 3 fantastic speakers. We have Rebecca Roberts, a senior solicitor in our dispute resolution team, and she has a particular focus on data privacy. We've got Hannah Reid, who's a solicitor in our technology and commercial team and does lots of work in this space. And Sarah Curran, also a solicitor in our tech and commercial team, who will speak about some cyber issues. So data privacy might not always be thought of as the most sexiest of topics, but the reality is that we live in a data-driven society, and that has never been more apparent than at the moment, when we're all spending so much time working from home and dependent on our internet connections for work, play, and to socialize. So for me, and for many businesses coming out of lockdown, I think the future is data, data, data. During the Data Privacy Summer Series, you will hear from experts across the firm on different aspects of data protection and privacy law, who will offer an experienced view and practical insight into a number of topics. So in this session, we're going to be looking back at some of the key developments over the last 12 months and to discuss what you need to know now coming out of lockdown. In the next 2 sessions, later on in July and August, we're going to look at issues arising now and in the future, including regulatory updates on data transfers, data sharing, direct marketing, and privacy online. And we're also going to look at the future landscape of data privacy, issues that are coming to the fore like AI, new tech, the future of DSAR practice, and class actions. So turning to today's session, I'm going to try and launch some slides just now, which hopefully everyone will be able to see and view. And so these are the 4 points which we're going to talk through today. Hopefully everyone can see them. So for the first of these, I'm going to hand you over to Rebecca now, who's going to talk to us about ICO priorities and recent enforcement action.
Thank you, David. Morning, everyone. It's nice to be here virtually. So I'm going to talk about the steps that the ICO can take when it becomes aware of a potential data incident, and just looking over the past 12 months, how in practice it has actually been exercising those steps. So just before we go into the results and the numbers, just a quick reminder of what the ICO's enforcement powers are. So I've set out there the 4 types of notices that the ICO can issue. An information notice, that requires a controller or a processor to provide information to the ICO that she needs to carry out her functions. Typically, that's used where the ICO has received an appeal about a public authority's handling of an FOI request. An assessment notice gives the ICO exceptional powers to investigate the controller or the processor's compliance with data protection regulation. So that can include giving the ICO access to documents, the ability to enter premises, observe the processing activity, and to interview relevant individuals. And enforcement notices and penalty notices, this is what I'm going to focus on today. So enforcement notices, you can see these published on the ICO's website, and these are published where the ICO finds that the data controller or processor has breached a data protection principle. It will require the recipient to perform specific action to remedy the breach. So a typical example would be if there's been a failure by the controller to properly respond to a data subject access request, the enforcement notice could set out how the controller should be responding to that request and providing the information to the data subject. And lastly, but certainly not leastly, penalty notices. So these are the ones that everyone's afraid of and the ones that we see hitting the headlines. So these are issued for the most serious breaches. The level of the penalty does depend on the type of breach, but probably everyone on this call knows the maximum fine is €20 million or 4% of annual global turnover. whichever is greater. Before issuing that notice, the ICO does have to issue a notice of intent to fine and invite the recipient to make representations. And in practice, penalty notices can often be issued alongside an enforcement notice. A number of factors will influence what the ICO considers to be the appropriate notice to issue. These will include the nature and seriousness of the breach, the type of personal data that's affected, so if there is special category data such as health data or perhaps financial information that is open to being misused, that could make it a bit more serious and push it towards a penalty. Other factors would be how many data subjects have been affected, how long the breach went on undetected, and whether the incident has kind of shone a light on more systemic issues with the processor and controller that need to be addressed now, or a similar thing could happen again. So moving on to the next slide. So these are the statistics I pulled from the ICO's website, and this is the enforcement action that it's taken over the past year. So as you can see there, only 8 monetary penalties were issued. The largest of these was as high as £500,000. I think there were 3 in that amount, and the rest were lower. There have been 2 notices of intention to issue significant fines to Marriott and British Airways, which you will probably have seen in the press. I'll come on to discuss those in a moment. There were 5 enforcement notices issued last year, so those related to nuisance calls, failure to respond to GSARs, and failure to secure personal data. But before we move on, just to put those statistics into perspective, last year the UK reported over 22,000 data breaches. So the UK is actually placed 3rd in respect of the countries that report data incidents, so we come behind the Netherlands and Germany. So against that backdrop, you might be quite surprised to see that of all of those reporting activities, that's just culminated in a handful of actions that are set out there. So there's a few reasons that might be. Of course, a lot of the incidents that the UK controllers or processors have reported, they might just not have met the threshold for any penalties. But we think that there might have also been a capacity issue at the ICO. So over the last few years, the ICO, God bless them, have had quite a lot on their plate. So there's been obviously the GDPR and the Data Protection Act regimes coming into place. They've also had a few large-scale investigations to deal with, like the Facebook investigation. They've had their own Brexit preparations and now coronavirus. So in our experience, that's meant that the ICO has focused its resources on really the most serious breaches. And that's meant that some of the lower level incidents that could have potentially attracted sanctions technically under the legislation actually haven't been subject to any further action. So moving on, I'm going to look at three case studies where the ICO has decided that a monetary penalty was appropriate. So firstly, Marriott. So it was actually almost a year ago now, July 2019, the ICO issued a notice of an intention to fine Marriott £99 million for GDPR infringements. The fine related to a cyber incident, which Marriott reported in November 2018. That incident had exposed a variety of personal data in relation to 339 million guest records across 31 countries in the EEA, 7 million of which related to UK data subjects. So just a bit of background about the incident. That vulnerability is believed to have gone back to 2014. Around that time, the systems of the Starwood Hotels Group had been compromised, and Marriott acquired Starwood in 2016, but it failed to discover the exposure of customer information until 2018. So the ICO's investigation found that Marriott had failed to undertake sufficient due diligence when it acquired Starwood, and it really should have done more to secure its systems. Now, the penalty notice hasn't yet been issued, which is why it didn't come within the 8 statistic that I mentioned earlier. Normally, the ICO has 6 months from issuing a notice of intent to actually issue the fine, but that period's been extended at least once, and the ICO has made a few vague public statements about the regulatory process being ongoing. And I've included there just a quote that the ICO made in her press release on this point, and it just kind of hammers home how she wants to make it clear that how seriously they take these incidents. And there is certainly the feeling that they have made an example of companies like Marriott and BA to act as a bit of a deterrent. So if you've had the opportunity to digest that, I'll move on. Thank you. So it was a busy month for the ICO that year. So the day before they issued the Marriott notice of intent, they issued a notice of intention to fine BA. And again, that fine related to a cyber incident. In that case, users of the BA website had been directed to a fraudulent site that then harvested their personal data. Around 500,000 customers are believed to have been affected. In fact, a few people on this call might have received the email that BA sent out at the time. The personal data that had been affected included login, payment card, and travel booking details. So the ICO had found that poor security arrangements at BA had allowed that cyber attack to take place. As with the Marriott notice, the final penalty hasn't been issued and the deadline for doing it has been extended. Of course, knowing the circumstances that we find ourselves in just now, we know that both Marriott and BA operate in two of the industries that have been hardest hit by the coronavirus crisis, and so they're already suffering extensive losses. You might say then that politically speaking, there could be a desire on the part of the ICO to wait until these industries show signs of bouncing back before issuing whopping great fines. The ICO hasn't said that, but it's just something to think about. And both companies will also have the opportunity to appeal these fines, it's worth pointing out. So, and there's another quote from the ICO. So moving on to the last case study, Cathay Pacific. So in terms of the scale of the penalty, this is quite a big jump down from the Marriott and BA cases. But I've included this because it is one of the highest fines that have actually been issued by the ICO, given that the BA and Marriott ones are actually still outstanding. So again, the circumstances surrounding this fine are a cyber attack. So this involved a brute force attack. So that's where the hacker or the program puts in numerous passwords in the hope of guessing the correct one, which it did in this case, and that allowed Cathay Pacific's systems to be breached. Malware was then installed and harvested customer data of over 9.4 million customers. So during the ICO's investigation, they found a catalogue of errors. There were backup files which hadn't been password protected. There were unpatched internet-facing servers, out-of-date operating systems, and inadequate antivirus protection. So it decided to issue a fine of £500,000. So what we see from these three examples is that one of the biggest risks to data controllers is cyber attack. These are the cases that can have the most significant impact on data subjects, the widest reach, and are the cases that have attracted the highest penalties from the ICO. Now, of course, it's not possible to absolutely eliminate the risk of cyber attacks, and even lawyers are not immune to it. I should know, I came from a firm that experienced quite a significant one in 2017. But the penalties that the ICO seeks to impose, they reflect the failure of the controllers to take appropriate steps to safeguard personal data and protect their systems. The important takeaway here is that a cyber breach might happen, but data controllers and processors just have to show that they've been diligent and proactive in taking steps to protect their systems and the personal data that they hold. So moving on to my last slide. So the future of ICO enforcement. Well, David's going to talk about the ICO's priorities during COVID-19 and beyond, but without cutting across that, one thing I would say is I've talked about how over the past 12 months the ICO seems to have been a bit stretched and has prioritised just the most serious breaches. I think we might see this begin to change now. After coronavirus and Brexit, and once things begin to sort of return to normal, the ICO will have more bandwidth to deal with data incidents of varying severity. In addition, after Brexit, we think that the ICO will probably want to show European regulators that it's got teeth when it comes to enforcement. A decision on UK adequacy is still outstanding, so we expect to see some stronger action from the ICO in the next year or two, just to demonstrate to European regulators that the UK does take a hard line to data privacy incidents. And you've already sort of seen that in statements from the ICO that have been included on those slides. So that's enough from me. If you have any questions on that section, like David said, just drop a message in the chat function and I'd be happy to speak about it, but I'll pass over to David. Thank you.
Thanks, Rebecca. I think that was a good whistle-stop tour of the bigger enforcement action over the last year or so. And so now I'm going to look at sort of lessons learned from what we've all experienced over the last few weeks, months. I think it would be quite easy to think that data privacy should take a back seat in times like these, that there are bigger and more important issues to tackle. But that would be wrong. That's perhaps not a completely unexpected thing for a data lawyer to say, but hey. But it's also the strong message that we're hearing loud and clear from the ICO, which is the UK data protection regulator responsible for overseeing how we process data. So data protection, data sharing, and data ethics may not have topped the list of everyone's priorities over the last few weeks. But as the weeks of lockdown have gone by, we're definitely seeing more businesses taking the opportunity to have a fresh look at their data compliance activities. I think that in part has been driven by some of the bigger data privacy stories that have hit the news of the last few weeks, including security concerns with e-meeting platforms, concerns about data collection and sharing practices of some of the big tech companies, and the numerous cyber breaches that have affected millions of customers' data. Rebecca's touched on a lot of those already. So what happens to data laws, practices, and activities over the next few weeks and months is likely to have a long-lasting impact. And without everything moving at such a pace at the moment, it will be difficult to go back to normal, wherever that was or is. So what are the regulators saying now? I think it's important to note the ICO has been providing some fantastic guidance throughout the crisis. And the regulators' basic message throughout has been it's business as usual. Data privacy is still, and perhaps increasingly, is important. Albeit that the regulators are aware that there are significant challenges which all businesses are facing at the moment due to the current crisis. But their consistent message, both the ICO and European regulators, is it's business as usual. One area the regulators have expressed a view on is in relation to employee data, particularly health-related data. And whilst it may be reasonable to request that employees notify their employers that they're experiencing symptoms, or for employers to take certain actions, etc., the key regulators is that considerate way data to employees, and the purposes are fully known, and it's not being done in an excessive and unnecessary way. Now, Hannah will pick up later on a wee bit more about workplace testing, but that's just an example of where the regulators have been singing from the same hymn sheet, as it were. So it's important to note that the ICO's team has suffered, as Rebecca said, and they haven't had the full momentum. So I haven't had the full resources to keep full momentum going in a number of areas. But having said that, they've just had a really busy month. They've reported on findings on the use of mobile phone extraction data by police forces. They've just laid the Information Commissioner's age-appropriate design code before Parliament, and there's ongoing guidance that they've just published in relation to data protection compliance during the COVID recovery period. And they've highlighted 6 key data protection steps for organisations to follow. And I'll quickly mention what those are, just in case you want to know. So 6 steps are: only collect and use what's necessary, don't collect excessive amounts of data, keep it to a minimum, be clear, open and honest with staff about their data. I mean, transparency is a key theme that comes through in GDPR, to be clear and open and honest with what you're doing with your data. Treat people fairly. Fairness is another key theme that seems to be coming out, and keep people's information secure. And the final thing is to enable staff to exercise their information rights. So if you haven't checked out the ICO's Coronavirus Information Hub yet, I think it's well worth a look, because there's some really good guidance on there that's very relevant and timely. The slide I've got up here is basically the priorities going forward, the ones that they think the ICO will have the greatest impact. And this is quite useful because it gives us an indication of where the ICO's thinking is going in the future. So the first is protecting the public interest. And there's a great focus on protecting vulnerable citizens and vulnerable citizens' data. So that's something we'll see more of. Responsible data sharing. we've heard a lot about various organisations, institutions and government agencies sharing data throughout the crisis, and I think there will be a renewed focus on responsible data sharing for all organisations going forward, so that's interesting. The other one is monitoring intrusive and disruptive tech, and clearly we're all heavy tech adopters over the last wee while, and some of the implications of that use is still to be sort of fed through. The next slide sets out the 6 priorities which the ICO have suggested is what they're going to look at going forward. So they range from protecting vulnerable citizens to supporting digitization. A number of our clients I know are going through some fairly fundamental digitization projects, and we're helping them with those, and that will only continue. And enabling good AI practice. So we are going to be picking up some of these themes in future sessions. I don't want to dwell on them right now. But what I wanted to look at now is what are the key data privacy risks, I suppose, that we've seen in the last few months and addressed, and what are likely to be the issues going forward. So I think, like most people on the call, remote working is the new norm and is likely to be for the foreseeable future, or blended working perhaps patterns anyway. And I think the whole situation has shone up light on certain data protection and security risks that might not necessarily have arisen if we continue with our normal working practices. So employers still under an obligation and duty to ensure that personal data to date and their employees' process are subject to appropriate technical and security measures, i.e. the regulations apply equally in a working from home scenario as much as they do to an in-office environment. And one aspect we've seen from working from home is the increased use of personal devices. So where employees have been asked to use their own devices as part of a remote working situation, perhaps connecting to office systems via Citrix or other platforms, this does raise a number of security questions. For example, there may not be the same level of appropriate technical and security measures in place on a personal device compared to the in-office IT setup, as these devices often lack tools such as end-to-end encryption, strong antivirus software, customized and secure firewalls, online backup tools, all these various things. And it's difficult for IT departments to keep a track of what's going on with personal devices and how data is being disseminated on those devices. So one of the risks there is maybe malware finding its way onto a personal device, and perhaps both personal data and also work-related information being compromised. So I think it's important for all organizations to just consider how their employees are working from home, and also to consider even company-issued devices, whether they are being adequately updated, etc. Third-party apps. I think the use of third-party apps and technologies has grown exponentially in the last few weeks. The sheer number of different tools and technologies we're now embracing, some pretty much from a standing start, is mind-blowing. These apps are designed in the main to replace processes and functionality that were no longer readily accessible or available to employees in a home environment. So video conferencing apps, team communication apps, scanning apps, and the rise of e-signing of documents. This is an area that's caught the media's and the regulators' attention, and questions are already being raised over security of these apps. But more importantly, the lack of due diligence that has been taken when onboarding and encouraging employees to use these technologies. Now, the law does provide that organizations ought to carry out DPIAs, data privacy impact assessments, to robustly assess the potential impact on personal data before adopting new apps and technologies. However, the reality is, for many, it's simply not been possible in the short timescales that everyone's been working to carry out the necessary due diligence. Now, the ICO is alive to this, but she will not turn a blind eye to this issue, particularly where individual privacy rights are at risk. And Hannah will pick up on the importance of DPIAs later. We're also seeing existing BAU business as usual risks. These are risks that we all know about, but we're seeing them being amplified and exacerbated by the current situation and working from home in particular. So there ought to be an increased focus on simple, some would say pretty mundane, data processing risks that exist. The ones that have been largely mitigated, managed, or removed from our office environments, but are creeping back into our daily lives at home. So employees may have brought home or are printing larger than normal amounts of confidential documents. They may be surrounded by others, family, flatmates, partners, etc. The so-called insider threat. So all the basic stuff that we all know very well, you shouldn't ignore, such as not leaving confidential information out in the open. Be careful where you're having your Zoom calls or other online meetings so they're not being overheard. And don't forward emails and documents from your corporate environment to your personal email address if you can avoid it. Because strictly speaking, all of these things could amount to personal data breaches under GDPR and unauthorized disclosure of personal data, albeit perhaps not all of these ones are likely to be notifiable. So what should you do? Obvious things would be to take some practical steps to enhance your communications with employees, engage with them to explain risks, review your working from home training and policy for pertinent new reality. Do they need to be updated to ensure that employees, customers, and others know what's happening with their data, and are they transparent and clear? And ensure that all employees are aware of their obligations to report data breaches and giving them the confidence to do so, because I think that's important to create that culture whereby it's to do the right thing and talk about data breaches if they occur. So if you don't take these steps, I suppose the regulators have made it clear that they'll take a pretty dim view of matters, and that's really the strong message from regulators across Europe. So takeaway from this is that all businesses and organisations should invest some time to consider, understand, and address the data privacy risk and issues that are relevant to them now and when returning to the office, so as to avoid any potential data breaches, claims, loss of goodwill, and trust that may follow. So that's a canter through some of the COVID-related activities we're seeing. So I'm going to hand over now to Hannah, who will talk about DPIAs.
Thank you, David. Well, as David said, I'm going to speak to you about data privacy impact assessment, or DPIAs. It's not normally the most thrilling of topics, but I'm going to do my absolute best to jazz it up for you. So as David has already discussed, the way we work has changed over the last few months, and it's clear that it's not going to return to pre-COVID-19 normality anytime soon. Lots of employers and businesses are realising, perhaps for the first time, that they're able to do some, if not all, of their BAU activities remotely. And even for those who aren't able to do so, normal daily working routines, processes, and patterns will be changing significantly, at least in the short to medium term, as businesses are gradually getting back to normal. So to support these changing practices, it's going to be key that businesses keep existing DPIAs under review, and even more key to put them in place where businesses have perhaps not been up to scratch in this area of GDPR compliance in the past, or where new processes are being put in place. So if we can move on to the first slide there, David. Perfect. So I'm going to start with a bit of a recap on the basics. So under data protection laws, DPIAs are required to be put in place before starting to process personal data in a way that is likely to result in a high risk to individuals' rights and freedoms. Now, the ICO has published a non-exhaustive list setting out 10 types of processing for which a DPIA will always be required in the United Kingdom. These include, for example, where a business or organisation uses innovative technology, profiles individuals on a large scale, uses profiling or special case category data to decide on access to services, or processes biometric data, genetic data, or location data. Now, to me, it's clear that these situations may well have presented themselves to businesses and organisations over the last few months. So we've established when a DPIA might be needed, but what should it cover? So we can move on to the next slide. Thanks, David. So the key information that's going to be needed to be included on a DPIA is, first of all, the purposes for which personal data will be used post-processing. Secondly, an assessment of the data protection risks that might be involved. And thirdly, the measures envisaged by the business or organisation to address these risks. And what about the format? Well, they don't need to be long, detailed exercises. In fact, it's best to keep them simple because the business or organisation likely won't engage with it if it's very complex or lengthy. Having said that, it should really become part of any business's core GDPR compliance programme. DPIA should be kept constantly under review as and when the circumstances around the relevant processing change, and periodically to ensure that they're constantly up to date. Now, for those of you that might not have already come across these in the past, the ICO does have a template on their website that you can leverage, but keep in mind that it is designed to be more of a one-size-fits-all template, and it might be more detailed than is required on a case-by-case basis. Can we just move on to the next slide? So why has COVID-19 brought DPIAs to the forefront? Well, this has been a typically overlooked player in the GDPR compliance field so far. And why now might DPIAs be more important now than ever? Well, if we think about the data risks that David already covered, all of these would be easier understood and their associated risks quantified by undertaking a DPIA. For example, if we take the health screening on return to office example, this is going to involve a substantial amount of special category data, and showing that you've risk assessed the process and infrastructure you've put in place to carry out this testing before doing so will help to build trust between the employee and the employer at what has been a very worrying and uncertain time, especially where the consequences of a leak of data pointing to an individual who has perhaps arrived at the office symptomatic could be very damaging to that individual's health or well-being. This type of transparency may also reduce the likelihood of receiving any data subject access requests, which, as some of you will undoubtedly know, can be very time-consuming and very costly. If there are any gaps or vulnerabilities in the proposed system or process for gathering personal data, these can be identified at the outset and either fixed or mitigated, which would hopefully save you time and money in the long run. Now, to highlight the increased importance of complying with this particular requirement of GDPR, as David also discussed, there's been numerous data privacy concerns in relation to the Test and Trace app. And I would highlight, from the NHS that is, and I would highlight that a complaint was actually filed earlier in June with the ICO, citing that the NHS had failed to conduct a data privacy impact assessment, meaning that they had failed to carry out the necessary due diligence in relation to the privacy of essentially everyone in the United Kingdom. Now, this has actually now been undertaken by the NHS, but not perhaps entirely satisfactorily. It apparently lists risks such as re-identification of app users, reuse of contact tracing data for other purposes, and the potential impact of measures taken against individuals as a result of the data which has been input into the system, without addressing how these risks will be mitigated or addressed or eliminated. So apart from the obvious lack of compliance here, The issue highlights that the general public and indeed rights organisations are becoming increasingly savvy as to the exact requirements of the GDPR and will actually call out organisations, particularly the public sector, for non-compliance, even if businesses don't have DPIAs at the top of their agenda. So if we move on to the last slide, I will summarise my bit on DPIAs. So in summary, since the GDPR came into effect, we've noticed that DPIAs, much like a middle child like myself, tend to be a bit overlooked. And whilst we don't expect that COVID-19 is going to drastically change that attitude towards them, it's definitely a case in point for their use and importance, because now more than ever, businesses need to be able to show that they are keeping the rights of data subjects constantly under review, given how much working life has changed for so many and how much new technology and processes has been and will be relied upon to keep businesses running as normal. DPIAs will help to pinpoint specific areas of risk associated with new technology and new working environments and set out ways to eliminate or mitigate those risks, one of which will most certainly be cybersecurity, which leads nicely on to Sarah Curran, who's going to talk us through a bit more of cybersecurity issues relating to COVID-19. Sarah.
Thanks, Hannah. So I'm going to be speaking about another very exciting topic today, cybersecurity, and the issues that we've been presented with as a result of the coronavirus, as well as the risk going forward as we enter a new working world. So as David has mentioned, remote working is the new norm, at least for the foreseeable future, and it has highlighted certain data protection and security risks that might not necessarily have arisen if we had continued with normal work patterns. So the National Cyber Security Centre has issued guidance advising on how organisations can manage the cybersecurity challenges of increased home working, and has made a number of general recommendations for secure remote working going forward. Some employees, due to the nature of their role, may not be used to working remotely, and businesses might want to consider producing written how-to guides for employees on how to use different types of software at home. There has also been an increased use in personal devices, where employees have been asked to use their personal devices as part of remote working, perhaps connecting to office systems via Citrix or other platforms, and this typically raises more data protection and security questions. Therefore, it's important to ensure that devices encrypt data whilst at rest, which will protect data on the device to deal with these circumstances. If possible, businesses should install software using encryption for transmission of data in order to maintain a safe working environment. Businesses should also ensure that the staff are aware of the procedure for reporting any security issues. For example, sending regular emails and coronavirus updates detailing procedures that the company has in place for dealing with any IT or cybersecurity related issues. Businesses may also wish to run training sessions for those who do not regularly work at home to ensure that employees are comfortable with the systems for remote working and aware of how to spot scam emails. So if we can just move on to the next slide, please, David. The coronavirus is now possibly the largest ever cybersecurity threat that we have faced, and has presented cyber criminals with an unprecedented opportunity to launch phishing emails and fake websites. On the 17th of April, Google reported that it was blocking 18 million coronavirus scam emails every day. In response to this, Google has now announced the launch of a new Scam Spotter program to combat scams related to the pandemic, which recommends a three-step process for individuals to consider before disclosing personal information over the phone or via email. Phishing attacks are the #1 cause of data breaches. Hackers can easily send seemingly legitimate, deceptive emails with malicious links and attachments. Once an employee clicks on the link, a hacker is able to gain access to the employer's device. This can lead to unauthorized access to the company's systems and result in significant losses arising out of, for example, liability, data breach, regulatory sanction, and reputational damage. which can of course result in significant detriment to a company's share value. Businesses may expect increased amounts of sensitive personal health-related data processing, not least from monitoring the health and welfare of employees. We could just move on to the next slide, please, David. Financial data is, of course, also highly sought and heavily targeted by cyber criminals. The objective remains to obtain company and personal information, such as passwords and bank account details, and ultimately to obtain money. There are a number of basic steps which businesses can take to mitigate such risks. For example, ensure that IT and security employees are readily and easily contactable, heighten data access controls and restrict access where possible, ensure that data that is required to be transported is done so via protected mechanisms, ensure that data is adequately backed up and capable of recovery, test such backups and recovery systems, and regularly install updates to include new patches against evolving threats. And just on to the next slide, please, David. So the regulators have all been crystal clear that businesses are still under an obligation pursuant to Article 32 of the GDPR to ensure that the personal data which they and their employees process are subject to appropriate technical and security measures, i.e. the regulations apply in a work from home scenario as much as they do in the office environment. If a suspected data breach occurs, a business's incident response plan should be engaged, which will generally include the following points. The incident response plan will require immediate engagement. Each department will have their own distinct responsibilities when an incident has taken place in relation to investigation, damage limitation, reporting, and any post-incident review. One of the first things to do when there has been a data breach is to decide whether a notification is required, and if so, to which authorities. It is best practice to seek legal advice to help determine the position and notification and whether it is necessary. Failure to notify a notifiable breach to the proper entities in the correct way and at the right time exposes organisations to potential enforcement action by regulators. The ICO issued new guidance in April that announced a softer regulatory approach to enforcement of data breaches during the current crisis. But it has also said it will take a strong regulatory approach against any organisations breaching data protection laws and taking advantage of the current crisis. Organisations should therefore remain proactive in reporting data breaches where this is required. When a data incident is being investigated and contained, it is advantageous to a company for many of its communications relating to the incident to be protected from disclosure to third party and the courts by legal professional privilege. Various legal tests are applied to determine whether legal professional privilege should apply to communications, and lawyers can assist companies in navigating through this process. Data breaches can give rise to costly regulatory investigations. The ICO now has the power to impose a fine of up to €20 million, or 4% of the total annual worldwide turnover in the preceding financial year, whichever is higher. As I'm sure many of you will be aware, on the 19th of May, EasyJet confirmed that it was targeted in a highly sophisticated cyber attack where email addresses and travel details of approximately 9 million customers worldwide were accessed, out of which 2,208 customers had their credit and debit cards accessed. Organisations, both small and large, are at risk of sophisticated cyber attacks, especially during the current pandemic, when most organisations will have a proportion of their workforce working remotely. When suspicious activities within the IT system are identified or reported, organisations should bear in mind that the 72-hour reporting window starts when it is reasonably certain that a data breach might have occurred. If for any reason the time limit cannot be met, organisations will need to be prepared to explain the reasons for the delay. So following on from this, if we can just get to my last slide, David. Here are some of our top tips to take away from today's webinar in respect of cybersecurity. So businesses should closely read their cyber policies to know what they need to comply with to ensure coverage. Companies should have data breach response plans ready with responsibility for different tasks assigned to specific team members. Businesses should undertake a data mapping process, an information security audit if necessary. As Hannah mentioned, businesses should undertake a DPIA to help systematically analyse, identify and minimise the data protection risks of a project. Businesses should review and, if necessary, update their policies to ensure they take account of the new world of remote working and increased risk of cyber attacks. Businesses should consider setting up training and sessions and providing information to staff on how to securely work from home. And businesses should also ensure there are dedicated points of contact in place so that employees know who to notify should a data breach occur. The cyber threat facing organisations is on a new scale and is presenting new challenges for us all. Businesses must ensure that any new process or software that is introduced to manage this new working environment does not bring with it unintended cyber risks. So I hope that the information from us all this morning has been somewhat useful. And if there are any questions that you have, then we would be happy to help answer them now. Thank you.
Hi, thanks, Sarah. That's fantastic. So we've cantered through quite a number of different topics there, and I'm just going to try and pick up on some of the questions that have come through during the session. So I'm going to start with a question for you, Rebecca, if that's okay. It relates to the BA and Marriott fines, which you talked about at the outset, and the question is, do you think that these fines will end up being fined, the amounts the ICO has been notified, or will there be a bit of a climb down? Any thoughts on that?
Sure, I do have some thoughts. Thank you, Callum. Well, first of all, I think the delay is probably could be a first step in a climb down. And I think now, because they've delayed, it is going to be quite difficult for the ICO to impose such a whopping great fine, given the knock-on effect that would have on layoffs and things like that. So the ICO is in a bit of a difficult position because it could be criticised if it results in, any sort of collapse or restructuring within these companies. So that's tricky. But as I said before, I do think the ICO wants to show EU regulators that it does take these fines seriously. And we had the Facebook fine that was imposed a few years ago. That was under the Data Protection Act, not the GDPR. So the level of the fine was quite a bit lower. But that was subject to appeal by Facebook, and that ended up being settled between the ICO and Facebook. So the ICO, Facebook agreed to pay the fine, but they didn't accept liability under the notice. So the ICO has shown a bit of a flexible approach in that respect, but equally that could go the other way, because they might want to show that they're not going to do the same thing every time a big company tries to settle with them. I think there is the possibility that there will be a reduction, especially as the companies have had the opportunity to make significant representations. And I think if the ICO was able to present a reduction in the fine in a positive light by saying, BA have changed its processes, or Marriott has fixed problems in its systems and it won't happen again. If it's got a positive story to tell, then it might reduce the fines. But it's treading a thin line between wanting to seem helpful to the UK economy, or rather not unhelpful, but wanting to show that it is a serious regulator that will come down hard on these types of breaches. So I'm sorry, that's not a really direct answer, but I think that's all I can say for now.
Yeah, it's interesting. The ones you highlighted are the bigger ones, and these are the ones that got a lot of press time. So it will be really interesting to see how these ones resolve themselves, because that will be quite telling for future enforcement action and activity. So yeah. I think it's one of these ones we have to watch this space. And
I think there should be something on it soon, because I think the extensions have just recently expired. So either we'll see another extension or some kind of decision, and then potentially appeals. So something will happen soon, I'm sure.
Great, thank you, Rebecca. we've had a couple of questions relating to workplace testing in particular. Obviously, that's of significance to a number of businesses at the moment as we move from a lockdown back to trying to move back into some sort of semblance of normality. So we're not going to give sort of specific advice on this call, but the general theme from the questions is, you know, the first one I think was about a questionnaire to staff, and I think questionnaires to staff are sensible. And there was some questions about, you know, what kind of questions you can ask on that form: ethnicity, age, body mass index, and various other things. So I'll just pick up on that briefly, if that's okay, which is, I think we've touched on this already, which is workplace testing is something that the regulator has given quite a lot of thought to and provided quite a bit of guidance on. And it kind of flows from some of the issues and questions that surrounded the government's track and trace strategy. And the sorts of questions we've all been asking is sort of how much data is being captured by government, how long will it be kept for, what purpose is it being used for, who has access to it, and can I review the data that's collected about me? And these are the sorts of questions that I think employees will be thinking about when they are being asked to provide data to employers as part of the creating a safe environment for staff to return to. And you know, some of these points relate to very sensitive data, health data, and there's mention of maybe sharing it with the doctor as well. I'm not going to go into lots of detail about whether that's the right thing or wrong thing to do, but there is some sort of key takeaways that I think it would be worth just highlighting, and it kind of flows from what we were saying earlier about having that honest, open, transparent conversation with your employees and with your staff. The ICO's guidance is clear that they don't see data protection law as being a barrier to doing the right thing and protecting employees, etc. But it does require you to be responsible with the people's data and how you handle it. So some of the questions you might want to ask here are, you know, what is the purpose of the testing and what lawful basis are you relying on for processing test data? You have to prove a lawful basis, and you have to notify staff what that basis is. So many businesses are maybe relying on legitimate interest as being a potential basis which you want to rely on. Because I don't think consent is going to be a silver bullet here at all, because obviously we all know consent can be given, but it can also be withdrawn at any time. The other things is you need to look at steps to ensure that the data you've collected is adequate, relevant, and limited to what is necessary. That minimization principle I mentioned at the outset. And I think there's an argument that some of the questions that the questioner is wanting to ask to staff maybe perhaps go a wee bit beyond which would be what would be generally regarded as adequate, relevant, and limited. So coming back to Hannah's point, I think before you launch any questionnaire or launch any testing strategy, it's important to do the basics, the DPIAs, which is effectively a risk analysis, to work out what is the data you're wanting to capture, why are you capturing it, why is that needed, and is there a different way of approaching things which perhaps could look to minimize the amount of data that's actually being collected and indeed being shared. And also one of the key things is to make sure that however that data is collated, that it's only shared with the minimal amount of people within the organization who need to know it, and it's securely held, because you wouldn't want that data to be hacked or accessed inappropriately, and that will lead to a bigger risk to the business. So there is clearly quite a lot in the workplace testing area that I think to work through, what I would say is, go back to basics. How we think about the data privacy impact assessment and work it through that way. And be delighted to see if there's any follow-up advice we can provide on that space. Anyone else have anything on workplace testing? On the presenters? No? Okay. I think we just got a last minute or so here. So another question about training sessions for third sector groups. Good point, Elspeth. Certainly, I think these summer sessions are designed to be sector agnostic and basically give information advice to all sectors. But clearly, the third sector has some different challenges and issues coming out of COVID, and it's something we can certainly pick up on separately if that would be of relevance for a future session. So I'm aware we've got 2 minutes left to go. I'm very keen to see if we can wrap this up within time. So I don't think I see any other questions coming in. So just to say thank you very much for everyone's attendance today. Thank you for the interaction and questions, which has been really great. The next session will be coming up in a few weeks' time, so look out for that, and hopefully you'll be able to join in the sessions that are looking more future-looking forward. And as I say, this is going to be recorded, so it will be available to colleagues who perhaps haven't had a chance to tune in today. We hope you find that of use, and have a great rest of the day.
David, can I just jump in quickly there? There's a question, and I think it's coming from Leslie, about the workplace testing, and I just wanted to double check we answered that. So Leslie, your question was about workplace testing and whether you can inform other employees if someone tests positive. Well, I'll pick up a couple of things from what David had previously said. One of them was you need to make sure that the information you're giving, if you're giving the information, is limited, is as limited as possible. But you also need to balance your duties as an employer for health and safety of your employees with the privacy concerns of the individual that's tested positive. And the ICO has some great guidance online about workplace testing and all these considerations. And the general point is, in order to do that balancing act between the health and safety of all of your employees and the privacy of your one employee, you can inform other employees of a positive case, but if you can possibly not pass on names of the positive cases or any details that you really do not need to pass on in order to ensure the safety of your other employees, then you can do that. Data protection shouldn't be a barrier to you looking after the health and safety of your employees, but as long as you do it with the interests of the individual in mind and pass on as little information as you can whilst keeping the rest of your employees safe, then that should be fine from a data protection point of view.
Thank you, Hannah. That's amazing. So that's bang on 11. So I'm going to draw it to a close there, and have a great day all, and thank you for your attendance. Take care.